Thank you, sir. Claire?
This is case 2020-0001, Ronald McDonald versus Town of Raymond Planning Board, and Robert McDonald versus Town of Raymond Planning Board, and Robert McDonald et al. Versus Town of Raymond Zoning Board of Adjustment.
Mr. Gordon?
Good morning. May it please the court, I'm Joshua Gordon. I represent Kathleen and Robert McDonald, who are here today with their daughter. This case presents the question of what the phrase unnecessary hardship to the applicant means in the waiver statute. The Superior Court set forth the law as exists in Raymond, which is more restrictive than the statute and which hasn't been challenged. Waivers are granted only if they are required to avoid undue hardship to the applicant. However, the Planning Board and the Superior Court here considered only the details of the project when considering the unnecessary hardship to the applicant. The waiver statute, repeated in the Raymond regulation, however, distinguishes between land, site plan, and applicant in the very same sentence, and therefore they must be different. Applicant means a person applying. If the unnecessary hardship owes to the condition of the land, that's not applicant. If it is, the hardship is to the site plan or the project or the proposal, that's not applicant. Assuming the legislature wasn't interested in personal details, to the applicant, it means hardship to the developer's pocketbook. Here, there was no financial evidence. The developer resisted financial disclosure and rather promoted its design on aesthetic grounds. And therefore, the Planning Board had no applicant financial data to consider, and the remedy is reversal.
Well, why isn't it a hardship to the applicant if the plan that they've conceived can't be achieved?
Well, it might be hardship to the applicant, but I think you'd have to show that that's a hardship to the applicant. I think the way the Planning Board and then the Superior Court conceptualized it, that was hardship really to the project or to the site plan. That's different than hardship to the applicant. I see the applicant as evidence such as if I do it this way, it's going to cost a lot more, and therefore I won't be able to build it. Might be, with the data of how much more it costs. That would be hardship to the applicant.
Are an applicant's financial means reviewed pursuant to the condominium review process at the Attorney General's office?
Yes, they are, and also I think there's other agencies, bonding agencies that might do that, but that's long after the Planning Board might approve that, and it's also for different purposes. Will the bond be fulfilled? That's a stage long after the Planning Board does its thing, but not in time for the Planning Board to review hardship to the applicant. So I think that's largely irrelevant.
Are marketability concerns captured in hardship to the applicant? I think here there was data showing that changes might make the units less marketable. So where do we factor that in?
I think that might be the sort of financial data, but the only evidence in this record is Mr. Marden said, it'll be less marketable. He didn't show it. He asserted it, but he didn't show it. But that, I think, might be the sort of information that the Planning Board would want to review. What is the market in the area from maybe an economic expert or something like that, and what's the housing market and so forth. I think that's the sort of financial data you'd want.
Mr. Gordon, what's our standard of review here?
It's my burden to show that the Superior Court and the Planning Board did it wrong, or unlawfully, or unreasonably, and it's unlawful in my case because to the applicant was here it wasn't to the applicant. The harm shown was to the project or the site plan, not to the applicant. So I have to show that that's unlawful, and I believe it was.
But aren't you asking us to get behind factual findings of the trial court?
No, absolutely not. There's no dispute about the facts here. I know both briefs set them off slightly differently, but there's really no dispute about the facts. And there's not asking the court to review really the facts. It's what is the hardship to the applicant, and was that proven? And I think given that there was no financial data, that's not a hard call. The issue is a legal issue of what does hardship to the applicant mean in the waiver statute.
So if we were to think of this in terms of the planning board listening to the applicant and saying, well, you know, that 50-foot requirement, that really doesn't work for this kind of neighborhood, dense neighborhood with low speeds when these roads aren't going to become public. So it seems, why is it not within the power under these regulations of the planning board to say, oh, you know, that really imposes restrictions on the applicant that make this a less attractive project and less financially viable, and we don't need to have dollars and cents attached to it. That's common sense.
And I think that's what the legislature enacted in 2009, and it appears that Raymond added the 2009 legislation to its regulations, but it didn't repeal the earlier ones. So you have this Raymond ordinance that has its old provisions plus those. Had it adopted only the 2009 statute, then the developer would have been able to make that sort of waiver on spirit and intent of the regulations and so forth. But in Raymond, they didn't repeal the old portion of the regulation. So they're stuck with this hybrid, and the Superior Court construed these provisions together, the sort of what Raymond has, the old one and the new one together, and said that, you'll see it quoted in my reply brief, that in Raymond, the regulations require a showing of hardship to the applicant. And nobody appealed that or challenged that. And so as far as we are concerned now, that's the law in Raymond, odd as it seems.
Can you just clarify for me, what's the 2009 change that you're alluding to?
That's RSA 674-44-3E. And if you look at the site plan regulations 7.009, which are in my brief, the new statute is the 02 section, the old portion is the 01 section, and these things have to be construed together, which is what the Superior Court did. So because there's no evidence of financial hardship to the applicant in the record really at all, with regard to one of the waivers, there was some evidence with regard to to what kind of pipe will be used, but beyond that, there was no evidence for of hardship to the, unnecessary hardship to the applicant for the overall waiver of the road regulations, which is what we're concerned with here.
So what's the financial information that you say needed to be filed that would have made this an okay exercise of the planning board's authority?
Sure. As far as the McDonald's are concerned, they're about 100 feet below the high portion of this land. And the water flows down to there in a culvert, really right near the property.
Isn't that a disputed fact?
Pardon me?
Isn't that a disputed fact? How many feet below?
I don't think so. Look at the topographical map that's in my appendix at page 307. The high point is about 260-something feet, and they're just under 160 feet. So even if it's off by a foot or two, it's about 100 feet. And what they're concerned about is this whole project is a very drastic disturbance of the natural drainage, and in the event that this project doesn't get completed or goes halfway or gets completed and then can't be maintained, there's no municipal resources behind any of it. And so you would want financial evidence would be, to answer that question, would be what is the financial viability of this company in the long term? Are they bonded? Is there some provision for maintenance in the years out? And because the road are not compliant with town or really any other standards, the town won't be able to take over the road, won't be able to adopt the road, so there'll never be a municipality involved in it.
So I understand the interest in bonding to make sure that the developer adheres to its representations, but I don't understand how that fits with financial hardship. Those seem like separate concepts to me.
To me, they are very much the same. What the whether the developer has the capability to see this project through 11 or 13 or however many phases they are going to put it through. If it dies after phase 1 and all the infrastructure is not installed, my clients are at the bottom of the hill and the water is going to flood their house.
So that just seems like a bonding issue.
Well, it might be a bonding issue, but still it's a financial viability issue. However it is solved, whether it's
So
through
where's
bond or
that
something
equal
else.
financial hardship? I don't understand where the nexus is with the hardship analysis.
Well, in order to get that's what the statute and the regulation requires. In order to get the waiver, they have to show that they're financially hard, that they will be financially undone, I suppose, if they were to comply with the road regulations. And if they can't, then that's a financial hardship, and they would have to show that. Thank you very much.
Thank you. Counsel?
Thank you. I understand, I think my clients understand the traffic waivers for the developers' aesthetic and marketing choices. But in Raymond, there must be unnecessary hardship to the applicant. And the Raymond regulation and the statute use the words land, site plan, and applicant in the same sentence, and they have to be distinguished. And whether it's, we would all pass that legislation or not, that unnecessary hardship to the applicant must mean something different than unnecessary hardship to the site plan, which I think was what my sister's focusing on. And what is the content of the word applicant? That's the issue for this court. I think it means financial information. I theoretically could mean something else, but I think that's what it means. But in any case, it must be distinguished from land on the one hand, like in the variance context, site plan, which is the project, and applicant, which is what we're talking about here. Thank you.
Thank you, Mr. Gordon. Case submitted. Court stands in recess.